Unfortunately, the notes in the file indicate that the defendant has recently told the victim in this matter that he will never pay her and the court can F off, quote unquote.
Indicates having, he says he bought his oldest son his first vehicle, paid $3,000 for that vehicle.
I don't know if I have yet sentenced somebody to prison and 7 years on the bench for not paying child support, but I'm going to.
What you just watched, that was the moment the floor dropped out for Joe Green. From buying trucks to allegedly telling the court to F off, you haven't seen the evidence that led to this total collapse. Joe Green is a heavy equipment operator who claims he's ready to work, yet his children are owed over $48,000. His defense highlights a $3,000 truck he bought for his son as proof of care. But if he has that kind of cash, why was his last payment only $300? During probation, his debt didn't shrink. It actually grew by $10,000. Is he truly struggling? Or is he just showing the legal system total contempt? To understand the legal tells that signal a judge is about to hand down a prison sentence, hit subscribe for more expert courtroom breakdowns. Let's go back to the start of this sentencing.
All right, this then is People v. Joe Green, file 24-93344FH, up for sentencing on a probation violation in a child support case. Counsel, you want to state your appearances, beginning with the Attorney General's office?
Good morning, Your Honor. Carrie Angie on behalf of the Attorney General's office.
Good morning.
Your Honor, Mike Vogler representing Joe Green.
Okay, and Mr. Vogler and Mr. Green are present in the courtroom. Does the defense have any objection to the people appearing by video today?
No.
Okay. And have you had a chance to review the probation violation report with your client?
I have.
Any additions, corrections?
Yeah, just an addition. In the probationer's description of the violation, indicates having, he says he bought his oldest son his first vehicle. I wanted, I guess, an addition there that he paid $3,000 for that vehicle.
Okay, I have also bought my oldest son his first vehicle, which is a 1976 Ford F-150 custom pickup truck.
You go
He wants to insert there the price for it.
Yes.
How much was that?
$3,000.
So Agent Lesky, can we maybe in parentheses put the price 3,000 there for that? Okay. Any objection to that, Ms. Ange?
No, thank you.
All right. Any other additions, corrections, Mr. Vogler?
I just updating the jail credit by 14 more days, I think.
Yeah, that'd be yeah, because we had to adjourn it due to the blizzard. We now are sitting on 337 days credit. All right, and Ms. Ange, any additions, corrections to the probation violation report from the people?
No, Your Honor. Thank you.
Okay, Mr. Vogler, the advisory guidelines at the initial sentencing were 5 to 28 months. Any reason to revisit that scoring today?
No.
Ms. Ange, any reason to revisit that scoring today?
No, Judge, I believe those are accurate.
Okay, Mr. Vogler, anything you want to say in your client's behalf?
I guess just to start out, we would ask the court to go ahead and follow the recommendation here. If the court does that, essentially, with the sheriff's good time, Mr. Green would be leaving jail today. Although his payment history since he was released last time is rated, on the other hand, it's not totally empty either. He did get some money to his former wife and their for the benefit of their children. That was on the books, and then there was a couple of things, the vehicle and the things that are mentioned in my client's description of the violation, in which he paid a couple of other things amounting to maybe $600-700. The man has a lot of potential. It's unfortunate here that we remain here. He has so much potential. He showed it in the past. His ability to earn, his ability to run heavy equipment and things like that. He's very employable. But he also has a problem with drugs, and I don't know which. Looks like that's interfering with what he needs to do here. I think he's ready to rededicate himself to this. Obviously, if he doesn't, another felony charge along these lines could easily, be forthcoming.
Thank you, Mr. Vogler. Mr. Green, you don't have to say anything today, but it is allowed. Is there anything you want to say?
No, sir.
Ms. Anj, any recommendation from the people?
Judge, I want the court to be aware that as of March 26th of 2026, the arrears were $48,522.39. The last payment that was made was on December 4th of last year in the amount of $300. Unfortunately, the notes in the file indicate that the defendant has recently told the victim in this matter that he will never pay her and the court can F off, quote unquote. The probation violation information includes his failure to participate in substance abuse counseling. He's made 0 payments toward fines, costs, or arrearages. He's continuing to do drugs. When he was arrested this time around, he tested positive for not 1, not 2, but 3 different kinds of drugs, including methamphetamine, MDMA, and another drug here. He's in the last couple of years racked up a couple of different possession of methamphetamine convictions with multiple probation violations. He's failing to report. He quit his job. He's not paying. The guidelines, as you astutely pointed out earlier, Judge, are 5 to 28. Because of the open contempt this defendant has shown for this court and its orders, I would ask for the court to sentence him to the maximum amount allowable within the guidelines.
Thank you. Well, I mean, even setting that, I don't have enough information in front of me to conclude by a preponderance of the evidence that Mr. Green has made that statement, that the court can F off. So, I mean, certainly it's fine for the people to bring that to the court's attention, but I think, I'll disregard that for sentencing purposes today, not having heard by preponderance of the evidence that took place. But even laying that aside, Mr. Green, I do have a lot of concerns here. I mean, I've had you on probation in some other cases. You haven't done well on probation. In this case, it's probation for failing to pay child support with a habitual second. Obviously, jail or prison is not on the first part of anybody's mind when we're talking about a child support case. But here, this case was pretty extreme. Started out when you were initially sentenced on probation here. Your arrears were $38,000. That's a lot of money in arrears. While you've been on probation, those arrears have grown. They haven't gone down. So those arrears have grown by $10,000. So now today, when we started you on probation, you owed $38,000 plus. Now you owe $48,000 plus. You failed to complete treatment that you were referred to. You kept using drugs. You quit your job. That doesn't really help with child support. You failed to report to your probation agent, and we had to get a warrant for your arrest. And your arrears are $10,000 more. I mean, I don't know if I have yet sentenced somebody to prison in 7 years on the bench for not paying child support, but I'm going to today, Mr. Green. It is time to go. There's no other tools left in my toolbox. I think 16 months is near the guide point, the midpoint. It's the midpoint and then rounding down. It's like 16 and a half or something. So I would find, based on this really awful record of probationary compliance, midpoint of the advisory guideline range is certainly a proportionate offense to the seriousness of these circumstances in your history and your performance. So I'm going to revoke your probation and commit you to the Michigan Department of Corrections for not less than 16 months, nor more than, what's the statutory max here? 70, okay. Nor more than 72 months, exercising my discretion under the habitual offender statute to increase the statutory maximum. I'll give you credit for 337 days previously served. So this will not be a very long trip to the DOC before you're eligible for parole. But I do think it's time you make that trip. You can file an application for leave to appeal if you wish. If you want a lawyer appointed, you'd have to ask within 6 months. We're going to hand you a piece of paper about your appeal rights and ask you to sign initial a copy so we have a record we gave it to you. The other ones for you to fill out if you want to appeal. When you're paroled and you're back out, you still owe this child support. So, I mean, we're going to keep coming back on non-payment contempts, and perhaps the prosecutor attorney general can bring charges for failing to pay from this point forward. It's not double jeopardy if it counts, anything from today forward that you're not paying what you're supposed to. So I don't know. I'm setting aside the statements that you've allegedly made. If that's your attitude, I hope you see where that's getting you today. But even if it's not your attitude, your complete failure to comply is getting you where you're going today. So you have to make reasonable efforts, sir. Good luck to you. Thank you, Ms. Andrew.
Thank you, Your Honor.
The judge made his call. Joe Green is heading to prison for up to 72 months. But here's the question. Was justice actually served here? Or does sending Joe to prison just ensure those kids never get paid? Comment below, team prosecution or team defense? Who do you think was really in the right? If this case got you thinking, hit like. Share this with anyone who loves a high-stakes courtroom drama.